Let's now turn to the United States with Kim Davis, the Kentucky clerk who was sent to jail for refusing to issue same-sex marriage licenses, being released back on Tuesday. She was still ordered, however, not to interfere with her deputy's issuing of marriage licenses to legally eligible couples. Dr. Michael Brown, President and Professor of Practical Theology at the Fire School of Ministry, joins us. Good morning from Seoul.
Hey, great to be with you. Thank you.
And thank you for joining us. And Mr. Daniel Cannon, a civil and constitutional rights lawyer, Clay, Daniel, Walton and Adams, a practical law company, but who was also very much involved in protecting a couple from Kim Davis, you might say. Thank you for joining us.
Hey, Alex. Thanks for having me.
And if I could start with you, Mr. Cannon, U.S. District Judge David Bunning found Kim Davis in contempt of court, but later released her from jail. Can you explain that decision for us?
Sure. Well, in general in the United States, if someone is in flagrant violation of a court order, they can be held in contempt of court. And there's two ways that can happen. One is civil contempt and one is criminal contempt. And the district judge here has an array of different sanctions that he can levy against someone who is in contempt of court for violating an order. And those include financial penalties and jail time and whatever the judge sees fit to essentially coerce someone into following the order and achieve compliance with that order. And that's what happened to Ms. Davis.
So there are some rather serious consequences, in certain cases at least, of refusing to do your job or refusing to carry out a given service for religious reasons.
Well, this instance in particular was an instance of Ms. Davis refusing a court order and appearing in front of a judge numerous times to say, I'm not going to follow your order. I'm not going to do my job, and I'm not going to do what the people of Rowan County elected me to do. And obviously, I think anyone in the United States knows that if you tell a judge, I'm not going to follow your order, jail time is always on the table.
Dr. Brown, what do you make of all this? Is there any justification for Kim Davis's refusal to issue marriage licenses to same-sex couples?
Well, of course. What happened to her is completely and utterly outrageous. The people of Rowan County elected her not to give same-sex marriage certificates. The people of Kentucky voted 75% to 25% in 2004, reaffirming that marriage is the union of a man and a woman. The 4 dissenting justices in the June 26 Supreme Court decision made it clear that this was a lawless, reckless decision with no constitutional foundation whatsoever. Justice Kennedy basically invented this out of whole cloth, and the arguments that he used supporting a same-sex marriage could be used by polyamorous and polygamists and many others. It's completely bogus. Not only so, but Kentucky has what's called the Religious Freedom Restoration Act, where the government is required to do what it can to accommodate deeply felt religious beliefs as long as it creates no undue hardship. There were numerous accommodations that could have very well been offered. There were online applications that were suggested. There were numerous things. What the judge did is outrageous. It's judicial tyranny. What Kim Davis did was the right thing. What I find ironic is when it went the other way, when you had the mayor of San Francisco in 2004, Gavin Newsom, saying that he was now going to issue same-sex marriage certificates, even though it was illegal to do so. He got hailed as a champion. He wasn't fined, and he didn't go to jail. The real issue here is not defying a court order. Justice Bunning completely overstepped his bounds here and is at least going in the right direction to try to fix this. The real issue here is, can a Christian hold Christian beliefs in America where the majority of the people profess Christianity? That's the real issue.
Dr. Brown, without going too far into a theological debate, within the Gospels, which would surely be the foundation of Kim Davis's beliefs, there is this sense of rendering to Caesar what is Caesar's, for example, of obeying laws. This is not a religious marriage. This is a legal marriage that we're talking about. Is Kim Davis within her rights to take this kind of stance as a judge or as a Kentucky clerk rather than as a priest or as a minister?
Well, of course. First thing, freedom of religion is a foundation in American life. Second thing, as I said, you have the Religious Freedom Restoration Act to protect people from these very things. And thirdly, we don't make a distinction where religion stops when morality comes in. When President Lincoln in the United States, many Americans ignored the ruling of the Supreme Court, Dred Scott, that a black person was less than a human being. They were not separating religion from morality. They go hand in hand. When people make ethical decisions in their lives every single day, things go hand in hand. The New Testament gives clear examples where the apostles and others refused to obey earthly authority when the earthly authority required them to disobey heavenly authority. So this is a long-standing tradition within Christianity, within the Bible itself. We normally commend those as heroes who act on their conscience. And fine, she went to jail. She was willing to do that. If that's the consequence, fine. I just say it's outrageous, and it's a sad day for America. And same-sex couples, if they want to go to the next county or have someone else recognize their wedding, that's fine. There was no real hardship involved, and that's why even critics of Kim Davis said it was outrageous that she was put in jail.
Mr. Cannon, why didn't your clients do that, just go to the next county? Was this an issue of principle for them and for you?
Well, look, there's no reason in the world why our clients or anybody else that is a citizen of Rowan County should be forced to go 30, 60, or however far away from the county that they, miles rather, from the county that they live in. They pay taxes in, they go to school, they work there. There's no reason, first of all, why they should have to go to another county to get a marriage license from the person that was elected to issue marriage licenses. But beyond that, what your guest is suggesting here is frankly quite a frightening precedent. If a judge were to say in this case, no, it's okay, you can go ahead and not issue licenses because it conflicts with your religious beliefs, then you can just go to the next county. Well, that's a simple accommodation, right? Just go over to the next county. The problem is with that is that we've got 120 counties in Kentucky, and the practical effect of that is to set up a quasi-theocracy in each one of those 120 counties where the law is dictated by the personal religious beliefs of the county clerk that is in each county, and that's just not the way we do things in the United States. We're a nation of laws. We're not a theocracy. We're not ruled by somebody's particular religious principles. And that sort of ties into the argument about the RFRAs, the Religious Freedom Restoration Acts, that your guest is alluding to. The problem with that argument is that those acts and the First Amendment itself are meant to protect people from the tyranny of government infringing upon their religious beliefs. And the elephant in the room here is that Kim Davis is the government. And in fact, what she's done here is in quote-unquote freely exercising her religious beliefs is actually imposed her own religious beliefs not only on her entire office by not allowing them to issue marriage licenses, whether it was against their religious principles or not, but also on her entire county, the people that she was elected to serve.
Yes. Thank you for that. Listener interaction, welcome. You can text us # 1013 for 51 per message. We've had the argument put the other way just there by Mr. Cannon. Let's go back to Dr. Brown and give you the opportunity of a rebuttal there. The suggestion that we would face a slightly chaotic situation were we to have a series of theocracies. I mean, Dr. Brown, you're not honestly suggesting that in the United States today we should be imposing Christianity on those who don't wish to be Christian? Isn't free will at the core of any loving religion?
Free will unless you're a Christian. I mean, this is really turning things completely on their head. This is the opposite of a theocracy. This is saying freedom from religion rather than freedom of religion. The founding fathers would have been shocked by rhetoric like that. You're talking about in the history of the human race, virtually all societies have recognized marriage, religious or non-religious, as the union of a man and woman or a combination of that. It was never two men or never two women in any large-scale way throughout society. It's never been the case in America, and the major religions of the world, several billion people hold to this. Now something completely new comes about. The people of Rowan County did not countenance the idea of two men or two women, quote, marrying. They did not elect Kim Davis to enforce this. There were simple solutions that would have inconvenienced no one, including online applications. The government failed in its protection of its workers. The RFRA is not to say if you work for the government you can't have a religious conviction. And people who throw this word theocracy around, here's a theocracy where you impose religion on someone else and give the death penalty if they violate it. A theocracy would be if you leave Christianity, we put you to death. A theocracy would be if you're gay, we throw you off a building. I find it obscene and offensive that word is thrown around when we're simply saying Christians have always held to this through the centuries. All religions have always held to this through the centuries. America has always held to this through the centuries. What was lawless is what the Supreme Court did. And the Supreme Court's going to have to recognize this is not just a randomly held belief. Right now in the state of North Carolina, where I live, there were 30 magistrates who were, by law, said you do not have to issue marriage certificates because it's going to violate your belief of same-sex marriage. Everybody's getting along fine. All they had to do was remove Kim Davis's name from certificates so that it would not have been under her name or authority. That was refused. There were simple solutions. To use the word theocracy to me is scare tactics, underhanded, and gets away from the foundations of who and what America really is.
Dr. Brown, quick question. Here in Korea, we had a situation where in May a district court acquitted 3 Jehovah's Witnesses who cited religious reasons for objecting to military service. Do you see that as a similar issue?
I do believe that you can be a conscientious objector. You have to serve your country in another way, but I do believe there's a place for religion and conscientious objection if it's not just a cop-out. Sure, there are fundamental religious beliefs held by different groups, and you do your best to accommodate it, again, unless there is undue burden that's put on the society because of it, which is not the case here. And you're going to have potential abuses. This is to try to balance it out. That's what we do in America. That's what we do in a free country. We work out ways to live in harmony with one another in the midst of our differences. That decidedly was not done with Kim Davis.
Mr. Cannon, I'd like to give you the final word on that particular point, also drawing in the comparison with other cases where religious freedom is cited. What would you want to add to that?
I mean, I think the court in Korea reached the right conclusion, and I think that we have protections set up in the United States, and rightly so, to protect the religious freedom of individuals, to protect them from being their religious freedoms and their religious beliefs from being infringed upon by the government. That is not the situation that you have with Kim Davis. Kim Davis is not a conscientious objector. A conscientious objector wants to opt out of something that the government is forcing them to do. Kim Davis is the government, and she's saying, I want to opt out of the law completely by imposing my religious beliefs on everybody in my office and everybody in my county. And so if she wants to opt out of her job, that's perfectly fine. That's what a conscientious objector wants to do. In the military, for example, you've got somebody that says, look, I don't want to sign up for military service because it violates my religious beliefs. And the government should accommodate that. But when she's going to take on the mantle of government and be an elected official and say, now I don't want to follow the law. I want to impose my own religious beliefs in place of the law. And that's exactly what happened here in Rowan County. That's a problem. That's not the way we do things in America.
Gentlemen, thank you both for joining us. We heard there from Mr. Daniel Cannon from Clay Daniel Walton and Adams PLC, and before that, Dr. Michael Brown from the Fire School of Ministry.